Go live, and we are live here on the our YouTube channel, Impact Litigation. I'm Chuck Cook, Aaron Hall, Greg Siskin. Hopefully Jeff will be joining us, but we wanted to jump right in, and so Lily doesn't get mad at me later, we want to make sure we put up our tag for what we are going to be talking about. Greg, you're a sideways. You're straight up and down today instead of sideways. Oh, and you're also muted. You're also muted, my friend. Sorry about that. Nope, we got nothing, Greg. You're not audioed. I'll let you figure that out. I'm going to turn to Aaron because Aaron's got to go, and that's not a euphemism. First of all, Aaron, I want to congratulate you on the massive win in the Go DV 2021 case. Because here's the thing. You know how many people would be getting a DV 2021 if we hadn't sued? None would be getting it. And now the goal is that they will issue all the visas, basically putting everybody at the exact place they would be if Department of State hadn't screwed them. That's anyway. So I want to let you take it from there. That's my input on yes, we won.
Yeah, that's right. We were, we've had a little bit of time to sit with the decision from Judge Mehta now, and you look at it, and he ruled in our favor on basically every substantive point about the illegal actions that the Department of State has taken in administrating the DV 2021 program. So, I mean, I'm thrilled with that. Now, I want to take it to the 30,000-foot view, kind of like Chuck just did. Without litigation, they were going to let DV 2021 basically pass without issuing visas. There's no doubt in my mind. I mean, there would have been a few here and there, but basically none. I think because of litigation, first of all, I think that helped force Biden's hand in rescinding the proclamation 10014.
No doubt about it. No doubt.
Second, it forced them having to report to the judge, forced them to ramp up scheduling here in the last month or two.
Don't forget the NIE exemption, which is also a result of litigation.
So way too late. Hello, Jeff.
Hi.
But they did ramp it up, and a lot of people are getting interviewed right now. So we're happy with that. And then it put us in a position where Judge Mehta is going to look at the numbers at the end of this month, and then he's going to decide if and how many visas to reserve. We are asking that he reserve the remainder of all 55,000. And we have made, since the order on Thursday, was it? we've reached out to government counsel, and we've basically told them, hey, why don't you just agree to that? Because President Biden says he's really concerned about the adverse effects on the DV program. Judge Mehta says you're going to have authority to reserve visas regardless of the deadline. So why not, just all agree that, hey, we're going to issue 55,000, all 55,000, and we can talk about the pace. We can come to an agreement on the pace of adjudication. And we haven't heard back on that, but that's what
maybe they don't like immigrants as much as they claim.
Well, that's right. It's time to step up and show where they are. But a couple of things that I wanted to address, and like Chuck said, unfortunately I have to jump off early today. But we're getting just floods and floods of questions about well, first of all, why didn't Judge Mehta prioritize Go plaintiffs? Is he going to prioritize Go plaintiffs in the reservation of visas at the end of the month when he makes that decision? So the answer is, we asked for him to make a specific order for our plaintiffs ordering adjudication before September 30th. He declined to do that. He referenced in his order the random order that they need to process DV visas in. He also referenced that in the last Gomez order. So when people are asking me, is he going to reserve visas, or please make him reserve visas for Go plaintiffs? Part of our role as attorneys is to speak frankly, and we will be asking for that. We will be asking that our plaintiffs be prioritized. And the reason is, when the government's doing something illegal, that affects so many people, certain people step up and they become plaintiffs and they challenge the government. And in my opinion, people who do that should be rewarded in the relief stage. But given what Judge Mehta said in this order and in the Gomez order, my expectation is that he will not. And that what he will say is that he's going to reserve some pot of visas and that he's going to order that they do it randomly. Now, we'll continue, even if he does that, we're still going to have a role in continuing to advocate for a number of things for our plaintiffs, including we're getting a ton of emails about problem consulates. So ex-consulate is not processing visas. They're not letting us transfer. They're not looking at people who aren't residents. We're already reaching out about that, and we will continue to do so. We'll raise that with the court if necessary, because just because somebody's in a place where a consulate isn't doing its job doesn't mean that they should be cut out of the randomized process. But is it our expectation, and you guys can disagree if you do, is it my expectation that he's going to make an order at the end of the month saying every Go plaintiff is prioritized and must be adjudicated with this reservation? No, I don't think it's going to happen at this point. Chuck, let me know if you disagree and you think I'm being overly pessimistic.
Well, I think it's consistent with what we said from the very beginning. We can't guarantee that to anybody, and that was never something that we promised anybody we would get. Keep in mind, the original Gomez order, in fact, did prioritize plaintiffs. They said, get as many people who were approved as possible. But the judge then, in his order this year, said, well, now it's random. Now, we're going to go back, and we'll have another hearing with him on the 23rd. I said, Judge, we want you to reconsider this, because in the original Gomez order last year, the plaintiffs that stepped forward, they had a chance to be interviewed. Not everybody got it, but the difference this year is, one, there's 24,000 plaintiffs in a different case. It's a massive difference. So basically, I think what the judge is saying is he's putting and the goal here is to get everybody back to where they would have been if the Department of State hadn't screwed you. Now, that to me is a great outcome, because that means the people that would have gotten the visas normally would get them. Now, one of the questions we get all the time is somebody, Joe Schmo, his number's lower than mine and he got a visa, or his number's higher than mine and he got a visa. Look, what does random mean? One, I don't think Judge Mehta understands what random means, because I'm not sure the Department of State understands what random means. They've certainly never been clear. Here's what I think random means. One, you got a number assigned to you. That was a random number. Then you were asked to go and fill out documents on the CAC website. Not everybody did that. Not all 130 people did that. So that's another random level. Then randomly, the KCC, and let's consider the fact they were incompetent in this, they send an email that said, hey, we got your stuff, send documents. Now, sometimes they said, hey, hold off and tell us when, we'll tell you when to send. Some they said send. Now, what you should do, and if you're DV 2022, what you should do is send your documents now. Don't wait for a letter. So some of you sent documents. Well, their position is number documentarily qualified. Then you're random. Okay, you're not random with your original number. You're random with DQ. And yes, we know that the KCC screwed a lot of you by not working on cases for 6 months. We emphasized that to the judge. He mentioned something briefly about that in his order. But again, we will bring this up, and we have brought it up before. But the reality is, every single year, people with higher numbers get green cards faster than lower numbers in a lot of different countries. The last thing to keep in mind is that every country is allotted a certain number of DVs. So it's not like, oh, my goodness, the consulate in Timbuktu, they're working really hard and they're going to interview everybody. Well, they are limited to it, whatever number it is for that country. They can't issue any more DVs than that. And I'm actually waiting for a response from Britt Simon because I can't find the number from last year. I'll give you an example. Bahamas gets 2 people. 2 people from the Bahamas get a DV every year. And more than 2 people apply. And more than 2 people win. So that means somebody doesn't get it every single year. And every country's got their limit. So the goal here, ultimately, with the reservation, Aaron, is reserving it for those countries that haven't gotten their visas. But I do want to mention, if it's okay with you, Aaron, I want to let our listeners know what questions we asked, so they will stop emailing us these exact same questions, because you're wasting your time and our time by having us pay attention to an email we've already answered. All right. So is that okay, Aaron, that I let people know what the questions are?
Yeah, of course.
All right. So first, will the Department of State, now this was sent last Friday, so it's only been a day. Will the Department of State be surging additional resources to the KCC to increase responsiveness, review of documents, and scheduling interviews? I could tell you I don't think so, but that's what we asked for. Again, we will share these with the judge, all right, if we don't get a response. At consulates that are not functional, will the Department of State be facilitating immediate transfers of cases to working consulates? The answer to that question so far is not really. Some consulates, I think Warsaw has gone out of its way to help people, as have a couple other Eastern European countries, but most have been useless. 3, clients report that Ankara has refused to schedule Iranian DVs. Yes, we got all your emails. I don't know how many there were, Aaron, but there were a lot. Stating they are only working on Turkish citizens. Will this consulate or any others be directed to interview Iranians? All right. 4, has guidance gone out to post regarding the order? Yes, Aaron, this is great. They did, right? They said they posted something this morning. I think it was this morning. And basically, it was said, yeah, if you get to it, you get to it. Not really a big deal. Work hard, but, don't worry about it. Now, here, Aaron, is something that concerns me. I read the order as you do, that their tiered prioritization program is garbage. That's how I read the order. Department of State is clearly not reading the order that way. I think they're limiting their review to the November memo, but not the tiered prioritization memo that came out this year. And that's quite a concern that I think we're going to have to address with the judge. Do you have an input on that? What do you think?
Well, if that's what they're doing, then that's explicitly what Judge Mehta rejected. They tried to say, well, don't look at November, look at April, where we actually said we took into account the DV 2021 when we made these priorities. And Judge Mehta said, no, that's post hoc rationalization, and I'm not going to consider it. I'm considering what went into your thought process in November, and you didn't consider the DV 2021 impact at all, while you did consider the timeline impact for other categories. So if that's the way that they're reading it, it's impermissible.
Well, we know they are reading it that way because we have at least 2 emails from 2 different consulates that said that, that they are looking at a tier 4 prioritization. So again, keep in mind, we're actually kind of on top of stuff. We appreciate your questions, but we probably already asked those questions.
Let me. Oh, go ahead. I was going to.
Fifth is, for the joint status report, it seems the information will come from the defendants. What are you going to give us? But we will be putting in our information in a joint status report. I can promise you. So if you're getting emails saying, screw you, you're a tier 4 prioritization, we're not going to get to you, we're not going to do Iranians, please send us a complete screenshot or the email so we can include it in our response. And then 6, in rescinding Presidential Proclamation 114, Biden significantly lamented the DV programs. Will you consider joining us in asking the judge to reserve all the visas?
Greg's waiting to be let back in.
Oh, sorry, Greg. I was reading something. Anyway, go, Aaron. I know you got to go.
Yeah. So a couple other things I wanted to address as far as client communications. A number of times we're getting, I think, groups of you. Well, first of all, we know it's September 13th. The deadline is September 30th.
What? Wait! It's September 13th? Crap!
We get the deadline is here. You're anxious. You want to make sure you're doing everything you can. We get it. That said, it is not helpful for a group of 40 of you to agree on copy and paste language and send 40 emails to me. That is not helpful.
For me.
And so please don't do that. If you have a group that wants to get across a message, send one. If for some reason I don't get back to you quickly, you're welcome to send it again. But, dozens and dozens and hundreds and hundreds and hundreds of emails are not really helpful when they're asking the same thing. So I get why you're doing it, but please Try to hold back.
Send hundreds of emails. Send them to Greg. Don't. Just kidding.
I will just
That was a
delete.
joke, okay?
Don't hear back. That's because you flooded me with messages.
Yeah,
It's not cool.
It's not good. We don't need these. All right, we got it. We understand what's going on. We understand the criteria. If you've got a piece of evidence that will help us in one of these 6 questions, feel free to send it. Do not send it 47 times.
Send it to Chuck. When he sends these invitations out to send emails, he means to
You're
him.
welcome to send it to me. You're welcome to send it to me.
Another question that I wanted to head off that might be asked in the comments, I'm not sure yet, is you might have seen some stuff on Twitter or wherever that there's a hearing in Good Luck, a status conference in Good Luck. Go is not invited to that, and there's a reason. It's because it only has to do with the consolidation of Rosales with Good Luck. Basically, they're trying to decide which parts of Rosales are moot because of Good Luck and Go, and so we're not invited because it has nothing to do with our case. So that's what's going on there.
We if they get into a discussion of the things we've talked about today, well, obviously we'll have somebody listening to the conference, but the reality is I don't think the judge is going to do that. I think it's going to be a logistical conference call in regards to those cases. But as far as we know, there's nothing going on that's going to impact Go plaintiffs in this. All right, Aaron, you need to leave. What can you say?
Wow.
We'll see you in a bit. All right. All right, guys. That was the Go DV 2020 update. We haven't heard back from the government, by the way. It's now been, over the weekend and today. We have followed up already today. Just so you know, we have followed up with the government counsel. We will follow up again tomorrow on that case to find out what's going on. You guys, Jeff, Craig, do you have anything to add on Go that you want to mention? All right. Again, a great victory, which means people are getting their visas. We have just now, one of our plaintiffs DM'd me. Montreal is interviewing her. Woohoo!
Finally, goodness.
Finally! Oh my gosh! I don't know what Montreal's doing all day long, but it must be a great place to work because nothing's getting done.
Chuck, I don't know if it's worth mentioning anything about the State Department cable that went out today about the case. Is there any?
Well, we briefly mentioned that a few minutes ago. Basically, the instruction was, yeah, we got this order against us, and we gotta make our best efforts. But that said, COVID.
Don't put yourself out.
Don't kill yourself. Now, entirely different from last year when they went bananas trying to solve the problem. Now, part of that may be that there are a lot of consulates that are interviewing people. There are at least 60 consulates that aren't interviewing anybody. A lot in Africa aren't interviewing anybody. But there's clearly lots of space available. So again, if you get an email from the consulate, we're not interviewing DVs, sorry, we're full, forward us that email because we will provide it to the judge in the status report to show that they are not making their best effort. Exhibit would be this update, this memo.
I've gotten a lot of updates from Go plaintiffs over the last couple of days that have been trying to transfer and getting pretty much universally denied transfers. So that's a little bit different than last year.
Oh, completely different because they bent over backwards last year to help people.
Yeah.
And we still have consulates like Russia, which they had 5,000 selectees. They're not doing anything. They're just closed.
Yeah.
So
we're definitely going to inform the judge of this, and hopefully.
I mean, it's just, the reality is we brought it up to him. He mentioned part of it in his decision, but they're not doing anything. He told them to try to do something, and they're doing nothing. It's really just like it's truly Trumpian in its response. It's the kind of response I would have anticipated last year when they jumped through every hoop they could get through, as opposed to this year. And actually, I think that helps us because, as a judge, unlike last year, when the department bent over backwards to documentarily qualify people, to give people interviews, to send them to other consulates, that didn't happen this year. And they made no real effort to get a lot of cases done in this time frame. They just did it. And that goes to the fact why you should reserve all of it, because it just shows a continual act of bad faith on the part of the government. And that can only be remedied by reserving the rest of the visas.
I think it's also, look, there's also a possibility that we could get a help from our Congress, because there is a provision in the language that was released on Saturday that allows for all the DB numbers from 2017, 2018 forward to be reclaimed and used. So, keep an eye on that, DB folks.
I mean, it is possible, Greg. It's possible, right? Congress passes a law on the 27th of September that recaptures all the visas, and Judge Maida says, case is moot now. That's possible.
Well, look, if Congress actually passed that, then I think we'll all be out drinking and celebrating, and we won't be so worried because everybody will be getting here.
And that bill does, in fact, help those that were subject to the Muslim ban over the last 4 years.
Yeah, I mean, it's pretty broad language. So if Congress we ought to know in the next couple of days. Today was the beginning of a markup in the House, and I'm feeling pretty good that it's going to pass the House.
Did you live tweet the markup? I thought you were going to live tweet the markup.
No, I didn't live tweet. Sorry about that.
You mentioned
Check in, but look, here's we will know in the next couple of days. I think the odds will go from probably about 50-50 right now to probably about 20 if the Senate parliamentarian approves this language. And we're going to know in the next couple of days, I think, what the parliamentarian is going to do. And once that happens, then it's just going to come down to whether they pass a spending bill or not. And that's a bit of an unknown. But I feel pretty optimistic that if we can get past the parliamentarian, this is going to become law.
Just don't pay attention to Joe Manchin, the man behind the curtain.
It's just that for Joe Manchin, it's just a price tag. They're going to reach a deal, and it's just a question of.
I read a CNN article today that talked about the Democrats' presentation to the parliamentarian, and either the reporter was a moron and didn't understand what Dems were doing, or the Dems did a really crappy job presenting to the parliamentarian on immigration, because all they had to do was hand the parliamentarian Alex Naraste's book, Resident Refuse, and say, approve this. Thank you very much. Have a nice day. The economy will boom.
Yeah, Ms. Gannon just put something out today that said that there'll be $1 trillion impact from
$1.5 trillion. The immigration is a massive pay for this bill. So,
well, one positive thing, and then we can move on because it's really not about litigation about this, is that in 2005, the last time they did this, it was a recapture provision that was what that bill was about, and the parliamentarian approved that. So that part of it, the parliamentarian would have to completely reverse precedent on that issue. But I think if she buys that, she's going to buy the whole package.
I agree.
17 pages.
It's a very easy package. It creates a new provision in the law, 245B. It gets rid of the backlog, essentially, right? If you have enough money. No backlog if you have enough money.
It's a huge money maker for the government. And just the fees alone, $50,000 a pop to get around the EB-5 per country quotas. That's that's a lot of dough.
It's almost hubristic, the amount of money they're asking for. You're sitting in a back room. What do you think we should ask for? I don't know. How much do they invest? Oh, they invested $500,000. Yeah. Ask for 10%. Really? Sure. That's 50 times more than we've ever asked for. That's okay. Ask for it.
But anyway, my prediction is we'll know by our next Monday YouTube whether this is likely to happen or not.
Yeah. By the way, one last thing on Go, a prediction from you. How many visas will the Department of State actually issue this fiscal year and thus require reservation? Any guesses?
I think they'll do 5,000 this month like they did last year.
Total. Well, give me total. How much will they have done?
How many were they up to before the decision?
Well, in July, they had like 11,000.
I don't know. I think they're going to fall short of last year, but probably not that much.
I think about 23 is what I think they're going to get to. They are interviewing a lot of people right now. And a lot of our Go plaintiffs are being interviewed. I've got a lot of news. All right, let's go to the next question, which is the Gomez Acker DV, we have no information. That's it. We have nothing. Sorry. Jeff, I want you to talk about our AOS EB delay litigation because we have a hearing tomorrow.
We do. So the last hearing that we had, as you know, was the question of whether the judge was going to consolidate the case with all the other mandamus cases that had been filed in Maryland against USCIS. And there was indication that the government was going to move to, transfer venue in all of those cases. And in fact, they did that in our case. They not only did they respond to our preliminary injunction, but they also filed a motion to dismiss based on various reasons, one of which was that venue's not proper. Now, what we do know is that we do have 4 plaintiffs from Maryland who are properly in the district court in Maryland. So the case definitely has plaintiffs who are properly suited in Maryland. And the plaintiffs get to choose the venue in which they file suit. So having properly filed in Maryland, there's no allegations by the government or the judge that the venue is improper, nor could there be because we followed the rules. The only real argument that the government's making in this motion to change venue is that aside from the 4 plaintiffs that are from Maryland, that the forum is more convenient for the other plaintiffs in the places where they reside. But they forget about a couple of points. The first is that sometimes in these cases, there's discovery and depositions. And they forgot to think about their own convenience, because what that means is their own attorneys are going to have to be flying all over the country from DC and Maryland, from headquarters to all these random places around the country for evidentiary hearings, potentially. They also forgot about the plaintiffs to the convenience to the attorneys for the plaintiffs, who are not admitted in every district court in the United States. Unlike the federal government, who is admitted and can go anywhere in the country, we're not. We have to get admitted to those district courts or apply for what's called pro hoc vice motions. So for a lot of reasons, this tactic by the government is ridiculous, nonsense. It's gamesmanship. We know that in other jurisdictions, the government's making the argument that venue is proper in Maryland, including in Washington, D.C. They're filing motions to change venue to Maryland because they're arguing that venue is proper. So we intend on pointing all of this out to the judge to argue that, in fact, we filed in the right place. We're challenging a policy determination. This isn't a bunch of individual mandamus cases. To the extent that we're challenging government policy, it makes sense to challenge it at government headquarters. So we're working on that. We also, as you know, filed our preliminary injunction to which the government responded. So we have a hearing tomorrow on all of that, on the motion to sever and change venue, as well as the preliminary injunction and motion to dismiss.
Now, Jeff, remember, we typically would have a reply brief due this week. So the judge set a hearing before we could reply to the government arguments. And we do get like 2 weeks to respond to a motion to dismiss and a motion to change venue. So he's having this anticipatory hearing, but at the same time, it's good. Because
it's good. Yeah. I mean, it's good. But, if you were present for the last hearing, I don't have a lot of faith that this judge is going to do anything in our plaintiff's benefit. I mean, he pretty much satellited and highlighted how he's going to rule in the hearing itself. I mean, he said when the government testified, he said, well, I don't see how you can be any more reasonable beyond what you're doing.
Are you referring to the testimony, the uncontested statements, not under oath, from government counsel and the acting deputy director of the agency?
Yeah. So for those of you that weren't present at the hearing or didn't know what happened at the hearing, this was supposed to be scheduled for a status conference, and the original order of the judge made it sound like he was going to take the government to task for all these cases being filed in Maryland and make them come up with a system that makes sense aside from a bunch of lawsuits. Well, what ended up happening at the hearing was completely the opposite of that. He gave the government attorney, the counsel for USCIS, and the USCIS associate director well over an hour of unrefuted testimony on why venue change was proper and why the agency was doing everything in their power to address these cases, which essentially goes to the heart of the argument on reasonableness. So I finally objected in the middle of this status conference and said, Your Honor, can I say something? And he said, no, this is a status conference. And I said, well, then I have an objection. And he said, you can't object. This is not for you. This is a status conference. And I said, well, I object to that ruling then, because I am present and I represent the plaintiffs here. And he basically said, this is status conference. This is not legal argument. And I said, with all due respect, you gave the government plenty of time to argue why venue is not appropriate here. And that is absolutely legal argument. And so, he ultimately told me to hold my tongue. Those were his words. Told me that he was going to excuse me from the hearing. I clarified.
He did excuse you from the hearing.
He did. He said, he thought I was Mr. Green. I clarified that I was Mr. Joseph, but he said, you're excused from the hearing. And I said, Your Honor, are you excusing me from this hearing? And then he backed up and said, no, I'm not excusing you, but you need to hold your tongue. And so anyways, this is how the hearing went. And I'm very, very glad that I made those objections.
Absolutely.
Because now we have a record when this judge does indeed try to change venue, that he's already ruled on this issue. He already ruled on it there. He already ruled on it at that hearing. And he shouldn't be sitting, if he can't be objective about this case, he shouldn't be sitting as the judge. So that's our position.
So we're going to have a really interesting hearing tomorrow. It's at 2:00, Jeff?
It's at 2:00 Eastern, correct?
Eastern time, which is still morning time. So you'll still be fresh as a daisy.
Yes, ready to go.
And make sure you have something so you're not hangry. Get a little bite to eat so you're not hangry at your lunchtime.
Yes.
You don't want to be hangry when you're in front of a federal judge.
Yes.
But we will update everybody when we have something from this hearing. Keep in mind, the key in the Chakrabarty case is to get a decision from a judge prior to the September 30th. Now, if in fact this bill passes and they reserve all the unused numbers in the category, then the case becomes moot. I mean, that's the fight, right? It's not moot because we still have the reasonableness argument on the cases, but there was a terrific Sixth Circuit, not this circuit, but different circuit decision today that went to the issue of what's reasonable. And immigration processing times are not per se reasonable just because they put them on their website. That was a great decision from our friend Brad Bamias on the U visas. It was a great decision from a Circuit Court of Appeals. So we've got that. We've got the Go decision now supporting our position for reservation of visas. So, again, it's still a really strong case. I feel very good about it. And we'll, of course, keep fighting for our plaintiffs. But we do know, if you're a plaintiff in Chakrabarty, if you've been interviewed and got your green card, you need to let us know. Hey, I got approved. We need to know if you're mooted out on this, because presumably the government will come in tomorrow prepared to talk about that, but we'll see. And then the question becomes, well, if you're going to adjudicate this person's case, why can't you do that person? I mean, clearly you're not. Actually, it's great evidence for us because the district acting deputy director said, we adjudicate cases in case order, which is literally not true, evidenced by the facts of this case. So kind of fun stuff. There's something else I wanted to talk about the Chakrabarty case.
There was a visa bulletin today.
Oh, yeah.
Yes, thank you, Greg. Greg, surely the visa bulletin jumped forward immensely.
Yeah, no. The visa bulletin was Charlie Oppenheim said it wasn't going to, that it wasn't going to advance. And in fact, the numbers are completely stalled. We had a retrogression on the date of filing chart, assuming USCIS is even taking a date using that chart. For EB3, we had, I think, a 1 month advancement in the date of filing chart. For EB2, which means that over the course of 12 months, it advanced a grand total of 1 month. So, it's a pretty good indication that people are going to be waiting a long.
Well, and it's good argument for us tomorrow. I mean, the reasonableness is inherent in their own application. They said.
Well, I think they've considered the fact that they already basically floated that they're going to be short 80,000, and I think that's reflected in the visa bulletin.
The thing with the visa bulletin is they didn't count for the family-based rollover that's coming. We know that they also said 100,000 or more family-based visas are going to roll over.
Yeah.
Where are those? I mean, that goes to this great evidence we have is their own numbers. They said last October, because the October visa bulletin is how many cases we will adjudicate in the next year, certainly in the next 3 months, but in the next year. And that's what they said they would do. That set their reasonable standard. And then a year later, they haven't done it. And worse, they took the money to do it. And now in their testimony last week, in their public statement that was uncontested last week, they said, we need more money to do these cases. What happened to the money I paid? I mean,
well, not only that, but what happens to, they made this thing about, we get money from two sources. 90% comes from user funding, right? The other 10% comes from appropriations. What they failed to tell you is that 10% that's for appropriations is almost entirely earmarked for E-Verify and investigations. It's not at all earmarked in any way for adjudications. So, it just lies out of there. And also the fact that it's user funded should mean that the purpose of those is to adjudicate, full stop. Right.
Yeah, they also made this fallacious argument that the Afghans are somehow causing problems. That they're doing all these free adjudications. I filed 30 Afghan humanitarian parole applications over the last week at our office. No one is doing fee waivers in those cases. In fact, these poor people are, filed the ones we filed today. Families of 6. They're going out and doing GoFundMe campaigns to come up with the filing fees for $575 per family member. Per person. Per family member. So these families, there's $4,000 a pop that USCIS is getting. They are making a lot of money on humanitarian parole applications for Afghans, which makes it particularly disgusting that they're trying to snow people into thinking there's a big charity operation at USCIS. People are afraid to request fee waivers because people are going to die while they're waiting on those fee waiver adjudications. And so the word on the street is don't file fee waivers. But first of all, you're probably going to get denied because the agency is not. Anyway. And second of all, your cases are going to be delayed.
Jeff?
It's flavor of the week too, right? What is the reason for the delay this week? This week, the flavor of the week is the Afghan crisis. Last week, it was COVID. The week before that, it was staffing issues and finances. They use whatever they can besides taking responsibility for their own decisions and inability to function adequately as an agency. That's the only thing they don't take responsibility.
They also failed to mention that last year, 4% of their money was transferred to ICE illegally. Kind of forgot to mention that. That they illegally took immigration fee money and put it over to ICE for enforcement purposes. I'm really looking forward to it. Jeff's going to be loaded. He's got the bandoliers completely full, multiple weapons, big giant helicopters. Yeah, he's ready. He's locked and loaded. All right, so that's the USA. Now, I also want to talk about our H-1B lottery abuse case. The government yesterday or Friday filed a motion to dismiss, which kind of a surprise, kind of not a surprise. I challenged the government lawyer. He basically said, well, he copied his boss. Yeah, well, you didn't do this and that. And I said, where's my discovery that you promised? Oh, we're working on that, but technically we don't have to give it to you now. So we'll deal with the motion to dismiss on this. We're going to win that motion to dismiss. It's a pure APA challenge. We've clearly have jurisdiction at the court to do an APA challenge. But if you are an H-1B employee, we'd love to have one more employer as a plaintiff because we would amend the complaint to add the employer. So we do have one affidavit we will put in our motion to dismiss, but I would suggest that we can get an employer would be very, very helpful at this point, just for the judge in that case. But that's what's happening. I have not had a chance to read it yet. I have one of our attorneys, Walid, is drafting the response right now. We actually will respond quickly on this. We're not going to wait the full 2 weeks, but we're going to go ahead and get that done. So that's just an update with that. Once I have a chance to review it, I will send out a little update called H-1B lottery abuse plaintiffs on that case. Let's see, anything else here? All of our K-1 cases are just sitting there. We're just waiting for decisions from the judges.
Although we did get a motion to dismiss in the King case last week.
So, which is typical what they're doing on these cases. So, we'll be.
Yeah, we're seeing some activity in Cairo also. Unfortunately, it's not positive where a lot of people are being put in administrative processing and being raked over the coals over there. And I don't think it's punishment or anything. I think it's just Cairo, but it's I'm not too happy with some of the correspondence I've had.
We also want to let you know we do have a new case that we are doing signups on. It's an EAD delays case. Go to that questionnaire, look at the FAQ, see if you qualify as a plaintiff. We'd love to have you as we move forward on that case. All right, let's take a look at the comments and questions. We have a lot of them here, and we will get through as many as we can before our hour is up, because nobody wants to watch a YouTube for an entire hour or longer. Does this mean that lower ranked, not documentarily qualified cases should be processed higher before higher ranked DQ'd cases? That's the exact opposite of what we said. What we said was, if you're documentarily qualified, that's where the ranking is. And sometimes you have a really high number, but I guess it does mean that. And you have a lower ranked number that's not DQ'd. Yeah, the higher person's going to. That's how State Department is interpreting random. That's their interpretation of random. It all depends. That's as I am. You guys understand it differently than that? That's how I understand that they interpret this. All right. So that's why getting documentarily qualified is so frustrating for people that didn't get it done, either because they didn't send the documents or they've been sitting on documents for the last year. Let's see. Montreal, I think I met it earlier, one of our Montreal TVs got interviewed coming up. I think it's on the 20th. AUS delays, no change finally. We talked about that. Let's see some other questions here. What's going to happen to the remaining Milligan plaintiffs? Jeff, you want to talk about that?
Yeah. So with the remaining Milligan plaintiffs, if we have another lawsuit where we are filing a lawsuit against a particular consulate, so for example, Manila, Rio, Moscow, etc., then we will transfer you over to one of those lawsuits if you would like. If you would like to remain in a case, we will transfer you over to one of those lawsuits. For the remainder of you, go ahead. Did you have a question?
What I was going to say is, what we're waiting for in each of those cases is the motion to dismiss.
Right.
We can't add you to a case until we get past the motion to dismiss stage. And winning those, we will add you to those relevant cases.
Yeah, if we survive the motion to dismiss,
which I think we will.
Then the case is still live, and at that point, before we file the motion for summary judgment, we can amend the complaint and/or file a motion to add plaintiffs. So,
Mr. Crilly is becoming very famous on the internet, apparently. Look, Joe's just not responding on that issue about how are they going to adjudicate Moscow. And it's still stunning to me. A friend of ours, David Beer, who works out in Rostad, Cato, said today that the Department of State has surpassed the USCIS in its nativist instincts. And he's right. They have. It is extraordinary that in the Biden administration, supposedly the pro-immigrant Biden administration, that the native is inherent in not quickly figuring out a solution for this has not been accomplished in the last 9 months. Absolutely stunning. Let's see. Again, Ramirez, we're still waiting on. That's it. A lot of these good. We already answered a lot of these. Greg, did EV3 retrogress? Or are they talking progression in November? I didn't read that in the visa bulletin.
I don't think it retrogressed. I think it was just the filing date chart retrogressed.
Filing date, but not the final action date.
I don't think so.
And obviously, why did filing date retrogress? They don't want any more cases.
Yeah, I think that's pretty clear. In fact, my guess is that state and USCIS have gotten together and basically decided that they are going to take a very conservative, very restrictive view about how many visas they anticipate coming over from the family side, and are basically they'll, we may see decent movement over the next couple of months as those numbers actually come, but I don't think they want to open the door to a lot of filings again like they did last year. That's what they're trying to prevent.
What's interesting, if this bill should pass, it's actually detrimental to employment-based cases. It's actually detrimental initially. Because
the bill passes?
Yeah, so if they say, look, because the bill says employment stays with employment, family stays with family. Well, they're only going to have 80,000, and they're 80,000 already accounted for applications, right?
Well, they'll get yeah. I mean, they'll get the $250,000. They'll get you can bypass the caps though. That's the part, Chuck, that's the big unknown is for $5,000. You get your green card regardless.
Right. But I'm saying without the extortion fee, right? So that's what it is, right? It's extortion.
It's the ultimate premium processing fee.
It is, but the thing is, you don't get premium processed. You're just going to sit in the reasonable line. But absent a change in the law, they'll get about 100 or plus thousand visas, right? If we were to win our case, they would have the 80,000. So they'd have 200,000 plus 140,000. So they'd have, 340,000 EB cases. But if the law passes, they're only going to have the 140. That's what and the 80 left over. So they're going to have.
Well, the other part, though, Chuck, that is the unknown is that the essential workers are a huge chunk of the backlog community, and they actually, for me, that was the biggest surprise in the bill, was that they got rid of this whole 5 or 6 year lawful provisional immigrant program that they had in the other bill, where you can't even get the green card until you've been in that temporary program for 5 years, and then citizenship comes 5 years after that. They got rid of that, and basically everybody gets to file for adjustment up front. I don't know how long it's going to take at USCIS to adjudicate these cases, but it will be a much faster path to citizenship. And essential workers includes information technology, communications, healthcare. I mean, a lot of categories for people that are that are plaintiffs in Chakrabarty. So that part of it, I think, is, and the fees are reasonable, and they get to file for adjustment too. So I don't think, I think if you say that this is worse for employment, I think you.
Well, in that context, you're not going to get as many visas.
Yeah, no. If this bill passes, people need to go out, drink, and celebrate. If you are an Indian high-skilled worker and this bill passes, this is the best news in generations.
The idea of per country limits goes away. Not that it gets
limited. Right. It won't. It essentially won't matter.
It essentially won't matter. So you just get a visa, and really, it's the ultimate money grab for the agency when you think about it.
I still hope that even if this bill passes, they'll deal with that issue. But nobody's going to care and object to ending per country quotas.
Because if you just pay an extra $5,000,
get rid of all the backlogs.
Think about it. For companies like Facebook or Google, write the check, right? Just who it hurts are little small employers or people that are nannies and something, that got to go through the regular process. But think about that. If they had 1 million people file AOSs with $5,000, that is like $5 billion. $5 billion. I mean, do the math. $5,000 times 1 million. That's $5 billion, right? Am I doing that math right, Jeff? Mm-hmm. $5 billion.
Yeah, add more, 3 more zeros.
How much of that do you think they can waste trying to modernize with IBM? At least $2 billion of that would be gone. Trying to modernize the e-filing portion of it. One question we've gotten a lot of is, can you help me on my individual case? Can you help me communicate with the KCC? I'll just tell you from our firm, we can't. We can't do individual cases. We're overwhelmed. We have all our work for our normal clients. I don't have the capacity to take on 1,000 KCC inquiries. There's a great place you can go to called alalawyers.net, alalawyers.net, and there's all these great immigration lawyers that are on there from ALA, and you can hire lots of lawyers to do the KCC part of the case. I will tell you honestly, though, I don't think it makes a hill of beans difference if we're trying to email the KCC or you are. They will equally ignore both of us. What do you guys have to say on that?
100% agree. Here's the other reason why our office has decided that we can't really take cases is because if we're only representing certain of you who are plaintiffs, but not others, then we're making calls and advocating on behalf of some of you, but not others. And it puts us in this weird position where we're sort of more representing certain of you than others. And so just across the board, we've decided we're doing what we're hired to do and nothing more, nothing less.
Yeah, I mean, I agree with that. We had plaintiffs that we had clients that we brought into the case, and that's a little bit different because they've been pre-existing clients. But I agree. But also, frankly, it's just a bandwidth issue right now. We have we're all really, and you don't need litigators for this. You just need a good immigration lawyer, and there's a lot of them.
Yeah, in addition to the advice that Chuck gave, where you can just get on AILA's website, I have sent out to my chapter, to the Rome District chapter, and to the Latin American chapter, basically letting people know if they have capacity to take these cases to let us know, and we will match them up with you. So if you want to email Shanya, CHANYA, at Immigration Issues, she'll match you up with one of those AILA lawyers around the country based on geography. If you're outside the country, we'll try and find somebody that can do it outside.
Somebody asked, should they file an individual DV lottery case right now? Sure, if you want to waste your money, that's a really good thing to do. Because I don't think any federal judge is going to hear your case and not defer the case to Judge Mehta.
Yeah.
Anywhere in the whole country.
Yeah, I mean, it's a universal order.
It's a universal order. It's already covered. There's no way an exception to that.
Plus, getting any meaningful relief in 12 days or 18 days on a individual mandamus is not realistic.
I love this question. Is it legal for a state to not move dates? Here's the deal. Department of State can do whatever they don't please. As was evidenced in August or June of 2007. When everybody became current magically. So yeah, they can do it. Doesn't mean we can't roast them for it, but you can absolutely do it.
There's our good friend Cyrus Mehta wrote this wonderful article about this legal theory that as long as one case has not been adjudicated for the year, that technically speaking, they could make the whole visa bulletin current and allow everybody to file adjustment applications on there, that the statute's that broad. And frankly, I think that's a great idea to do that. Just hold one visa back and you can adjudicate everybody.
You know,
that's why I love Cyrus. Adjustment applications early, you could do that. But they're not creative thinkers over at USCIS, unfortunately.
Okay. Oh, by the way, any update from Barry?
Oh, yeah. On the EBA.
Yeah, I mean, we're talking about Barry Walker, who is a great lawyer in Tupelo, Mississippi, who is he very seasoned, and he's a good immigration lawyer and a good litigator. Barry has a case for a little mini Chakrabarti case. He's got 5 plaintiffs that are seeking adjustment, and he's asking for very similar relief to us, to adjudicate by the end of the month, or for the judge to reserve visa numbers for them. He's had 2 preliminary injunction hearings. The second one was last week. He believes, based on sort of the interactions with the judge, that she's reasonable and is very interested. And, so we'll wait and see. Obviously, a good result in that case would be very helpful for us, but we'll have to see. But we're watching that case really closely, and Barry will let us know at the moment he gets anything.
All right. Got a couple more minutes here. What about KCC skipping thousands of consulates at working consulates while higher cases get DQ'd and receiving views? We just issued a status report. Well, that's great that you're tracking that. The reality is the KCC has acted in bad faith here. We've made that point many times. And again, the key is always we fight for all of our clients, all of the plaintiffs. And we also get the reservation of visas. It's been clear since November in Enunciado and certainly in the filing since April that they were not going to get to all the visas. It was
KCC didn't have the excuse that not that the consulate's excuse was so legitimate, but KCC had even worse of a case to say that COVID should have prevented them from really, going gangbusters and getting all this information in the system, getting all these cases ready to go. They had, every person in America has been working their butts off for the last 18 months and getting their jobs done. I don't know why KCC can't.
I agree. Manu was listening to the hearing in Chakrabarti where this deputy director said, yeah, everybody's got an EAD. I mean, what's the problem? I thought that was hubris. I mean, that was just absolutely. You mean with my EAD, I can apply for naturalization in 5 years? Is that what you mean? How good the EAD is?
My parents who are waiting to move in, rejoin the family and be with their grandchildren that are waiting years and years.
It was, I thought, an outrageous statement by her because you didn't pay for an EAD. An EAD, and in fact, an EAD is not even necessary if they would adjudicate your case. You just do the adjustment. Why do you need to do an advance parole and an EAD?
Yeah. Plus, how many elections are you not going to be able to vote in because of this? Yep.
Let's see. Somebody asked again. We answered this early on. The district court enjoined the Department of State from implying the prioritization guidance to selectees and this is the 4-tier prioritization. That one consulate today said you're a 4th tier. We'll get to you when we can.
Not anymore.
Well, that's what they said today, literally from a U.S. consulate. So wait do we tell the judge, hey, they clearly don't understand your order, which goes to the bad faith that they're doing. Okay. Hamza, as far as I know, the way you're going to recover lost DV 2020 is by Congress voting on the bill. That's the way it's going to happen. There is no public line tomorrow for the hearing. Is that right?
Can we go back to that previous question real quick?
Sure.
I heard a rumor that they were trying to address people that were double banned, that had proclamation bans and Muslim bans, that they are trying to figure out a way to reopen people that had been banned based on
the agency or Congress.
I don't know. Massa said something about it.
Oh, because it's in the bill.
It's in the bill.
Okay, so that's what it was. All right, so
the bill says anybody that was prevented from getting a DV from 2017 onwards because of a use of 212F, which is the Muslim ban, or COVID, will have those visas are all coming back.
Okay, so they will be able to recover that if the bill.
Yeah.
Okay. Good.
All right. Tomorrow there is no public line.
Yeah.
Well, this judge.
There's not even a line, by the way. I had to create the line.
Jeff had to literally set up the call.
I set up the call. So.
And Jeff doesn't have a conference number.
No, I haven't had one since.
And it's not a Zoom meeting either. It's literally, what is this, 1988? It's a conference call.
Yeah.
So there we go. Let's see. Is there anything else on here? Lots of question. Well, this is a great question. This is the extortion fee? Manu is right. First of all, I don't know lawyers that charge tens of thousands of dollars for H-1Bs. And personally, I hate the H-1B. They made it an extraordinarily terrible visa to have to use. And we don't really do that many of them here. But yeah, rather than paying, if you're going to renew your H-1B 10 times in the rest of your life, why wouldn't you pay $5,000? That's what they're counting on that. They're actually counting on the fact that they're so behind and they don't do their job that you will pay more money to get in a different line in which they won't do their job. Do you think by paying $5,000 and skipping line, of course, you will get your green card in this lifetime, but do you think it's going to be quick?
I'll tell you as well, just because we get trashed all the time, lawyers on social media that we just love H-1B fees. I don't think any of us mind the work from the H-1B, but in terms of the real pleasure that we get out of our work, it's when our clients get green cards and citizenship. Yeah. That's the real joy that we have in our practices, is when people get those kind of benefits. The non-immigrant stuff, it's like, is fine, but it doesn't really get I don't think anybody's like saying I'm in it for
H-1Bs. I'm an H-1B.
The H-1Bs or the F-1s and all that. No, we want our clients to get permanent residency and citizenship.
And those attorneys that are relying exclusively on H-1Bs for their practice are competing against each other for the lowest possible prices.
Yes.
They are competing at the bottom of the barrel, and they probably haven't raised their prices in 10 to 15 years for
These
H-1Bs.
big companies that do 1,000 H-1Bs,
Yeah.
they're charging nothing.
So don't complain so much about immigration lawyers' fees.
What I find interesting is that people don't become immigration lawyers to get rich.
Yeah.
They are literally, according to a recent study, the lowest paid lawyers are
But the happiest.
But they are the happiest at the same time because we love what we do.
Now,
One
we're
last
social workers with law degrees.
Jeff, this is a great question because Judge Boasberg is sitting at Kinsley. Now, we notified Judge Boasberg about the Go decision, didn't we?
Mm-hmm. We did. I hate to go out on a limb like this, but I think that is really, really highly unlikely that we lose on Kinsley, to be honest with you. I mean, because if you think about what we're challenging in Kinsley, it is pure proclamation. That's it.
Right. Well, it requires the judge to completely reverse it in Milligan.
Himself. He has to reverse himself because Boasberg was the judge in Milligan that gave us the preliminary injunction on the proclamation.
It happened, but I doubt it.
Yeah. So I just don't,
Why would, after we have 6 decisions now analyzing this issue, they've all gone the same way. And then you're asking a judge to reverse one of those decisions and himself. And to go a completely opposite direction, including from what he did. I mean, it just doesn't make any sense.
Yeah. And also, I know I hate to go back and, say, I told you so, what we did at the beginning. But if you remember, this was the reason we didn't add a mandamus claim to Kinsley, is that this was the case that took on the proclamation in a big way from across visa categories. And we wanted to just win on that issue. And so, I think it was really, looking back, it was really smart to keep it very narrow because I don't see a way out now. I think we win in Kinsley, and that's going to be good for everybody.
Yeah.
There's a good question here. Will the judge let you talk tomorrow?
Oh, boy.
I will tell you, if the judge does not let me talk tomorrow, then I'm going to file a motion to recuse.
Yeah, I think we have to do
because, based on what happened, now that we have the transcript and we see what was said, I think at that point, we don't get a fair hearing unless he lets us speak at some point.
Venkat reminds me, or no, I'm sorry, I missed the point. The visa bulletin said that may retrogress in November, and he is right. It does, in fact, say that here tomorrow, that it may retrogress in November.
But that gives you 6 weeks to file your cases.
Yeah,
but you have till the end of October, really.
I think the concern here is that people that have pending adjustments won't get a decision now for years.
Oh, yeah.
That's
so
very serious.
Thank you, DB on the net, for that. All right.
Yeah, and I think that's a really critical point. If we have a judge that's interested in really thinking about this, that's a pretty important argument.
Mm-hmm.
Now, Jeff and Greg, I want you to stay on the line after we say goodbye. I got a quick question for both of you. Everybody else, we're live. All of us are live this week. Follow us. We'll be there. We'll be updating you on things going on. All right.
Well, actually, no, I'm not going to be on tomorrow because we have our hearing.
Oh, that's right, at 2:00. So
so I will try, and I may have a sub during that time, but you won't be seeing me tomorrow because of that.
I'll be on Wednesday. Jeff, you're on Thursday. Is that right?
I'm on Thursday at 2:00 Eastern.
All at 2:00. Best time to come on our channels. All right. We'll see you guys later.